we must not waste our time playing in courts.
Mr. Netshitenzhe, we'll come back to this. We'll come back to this issue. We'll explore this issue of whether there's a likelihood that these other entities might challenge this in court. When we come back, please don't go away. We'll be back right after this. Welcome back. Stephen, McDonald says we should play in the courts. As a legal man, is there room that these people who are opposed to what the department is doing and government is doing, can they challenge this in court?
I think that personally my view is that the DTI and the NCR will be very careful to make sure that they are doing everything within the law and the Constitution. And I doubt very much there would be any substantive basis to go to court over it. Moreover, I think it would be really negative for credit providers, say, for example, to be going to court with the regulator. I think that's just not a good idea. But that said, as McDonald said, it is the right of anybody to go to court, and it is ultimately the decision for that particular court to make. Whether or not there's merit is for the lawyers concerned to consider. So far, I haven't heard of anybody thinking of going to court over this issue.
The one question I always wanted to know, why is it that long after a debt has been settled, you still have this adverse information at the credit bureaus?
Well, I think this is the problem that the DTI and the NCR have identified. We want to ensure that there's a culture of payment. And when you disincentivize people by saying, well, you can make payment, but bad luck, the negative information will remain on your credit record, that disincentivizes a person from making payment. So they are saying, we want to try and create a culture of payment, and if you make payment, we will therefore remove the negative information regarding that account from your credit record. There'll still be some information regarding your non-payment, but it won't be as negative. So the payment profile information will remain, but we'll remove the adverse information or the judgment information.
In other words, Mr. Netshitenzhe, what level of, probably both of you can take a dip at this question, what level of debt are we talking about? Obviously, you're not talking about property, or you're talking about small debt, or is it all debt?
Well, let McDonald answer. Personally, I think he's well placed.
Yeah. No, thanks. The debt that we're talking about is that they are varied, but we're talking about in the credit market, and then people have asked the credit, and then you find that the issue of mortgage generally, it has stabilized or it has gone down. People are settling debts in that area. But in other areas, you find that we have close to half of active consumers. Say, out of 20 million, we have half, which is 10 million. Those people are indebted. And therefore, we think it will be proper for us to remove those debts of, say, 5,000, 500, 10,000 and the like, and then the quantum number is that 1.6 million of people can benefit from that, and therefore we encourage that these people be alleviated, their situation be alleviated, and then they go back to the channels of commerce, and the economy should grow.
Stephen, do you want to add?
Yes, I can add to that the proposals don't distinguish between different types of credit. So, for example, home loans or credit cards or personal loans or vehicle finance. They say that the adverse information will be removed irrespective of the value. So it's a once-off removal where McDonald was trying to explain that adverse information doesn't really relate to home loans, for example. you'll see that judgments are more readily taken with regards to non-payment with a property. But when it comes to adverse information, it more readily relates to personal loans or to credit cards or to that type of loan. So those are the people who are more likely to be benefited. In terms of the total number of people, it's a minimum of 1.6 million people who will be benefited. But in terms of the amount, there's no limit on the amount that the adverse information that can be removed.
There's something else I want both of you to take a deep at, and that has to do with many graduates who took loans to go to universities. I saw recently that many provinces were chasing graduates who were not coming back and paying back their loans. And how is this going to affect them?
Well, again, I think that the key idea here is that we want to enable those students who have taken out credit that possibly they couldn't afford at some point and have now they want more credit, that their circumstances may well have changed. They may now be able to afford credit. So they should be given that opportunity and not be held liable for the sins, as it were, of the past.
MacDonald, do you want to take a deep at that?
Yes. I think here we have to analyze the situation correctly. Generally, students go to universities and they are not workers. And the guardians or parents enter into an agreement with the university to say we will settle the debts. It's sort of a surety. And therefore, when payment is not effected, it should be going to the parent or a guardian, generally, preferably. And then, if it is the student, him or herself, who has done that, and then now this student is going to get a degree and be employed. When he or she is employed, I think we should be saying this person now is going to earn a salary, and then that salary can erase certain debts. Why do you still have to put the impaired information in the credit bureau? So for us, we think if that person also is going to work and see to it that he is not actually employed in an area where he or she is dealing with finances. He's dealing with HR, for example. It is not related to the issue of dealing with money. So therefore, we need to interrogate these issues and come with a proper judgment. But we are saying now they are employed, these students, or they are potential employees. Therefore, they should be coming with a clean slate, unlike the students in the U.S. The U.S. was in crisis. Why? Because it was affording students who may take 10 years without working, still at school, and you find that they are afforded credit, even if they are not working. Credit in housing, motor vehicles, and the like. So therefore, we need sober minds to analyze this situation and remove this impaired information correctly.
That's where the problem lies. There are institutions that will not employ anybody, be it a graduate, comes out of university, if he has an adverse credit record.
So there already are provisions in the National Credit Act that say that you cannot go and check a person's credit record when they are applying for employment unless they are going to apply for a position of trust and the job relates to the handling of cash. But what is happening is that is being ignored, and all applicants, all job applicants, are having their credit records vetted. And even if that's not given as the reason, if, for example, there are 5 applicants for a job and one may be well qualified for the job, but if they have a negative credit record, they won't get ahead of the others. And so I think the feeling from the DTI and the NCR is that's unfair. And one of the ways that we can address it is to remove adverse information, because it's clearly a barrier. It's not the key barrier. The key barrier should be affordability.
Well, we'll come back to that, and I think many of you who are looking at going to find work after you're graduating from university, you might get solace from what has been said here today. When we come back, we'll look at recourse for those people whose